If an immigrant is experiencing unreasonable delays for an immigration benefit, example visas, green card, or administrative processing, you can seek an order to compel action on your case. This is commonly referred to as a mandamus lawsuit.
Mandamus is really a legal term that called for a writ of mandamus, but what we're talking about is really a delay, right? You want an immigration benefit and it's not happening and you're harmed because of the delay. And so you file, quote unquote, what a mandamus. Usually the cases are filed. The cause of action or what you want is not a mandamus. You really want relief under the Administrative Procedure Act. And, we can walk through the steps. There's really, number one, what benefit are you seeking and who's delaying the action? That's the first question we need to ask. Is it United States Citizenship and Immigration Services? Is it Department of State because you need a consular action? But through this litigation, we really just want to know, I need an action. I need you to do something, issue a decision, issue a benefit, schedule me for an interview, get me out of administrative processing, but something, okay? So the first step is who's delaying your case? Where is it? And how long has it been? That really matters. It's not a set abstract time. 180 days, 300 days. I hear that all the time. That's not true. What it's specific to what is exactly the benefit that you're seeking, right? Is it a immigrant visa petition at USCIS, or is it a admin processing because you're a student in need of visa and you're about to lose your place in line? So it's not a set number of time. It's really about what category or what benefit are you seeking. The way I work is I'll take that in, and if I agree to do the case, I usually commit to filing a case, but then 7 to 10 business days. And what we'll do is we'll describe what's your harms. That's the most important thing. It's not about how long you've waited. It's about how harmed you've been from the delays. And it's important that we get the story. And I need to hear that story from you. Maybe it's family separation. Maybe you're about to lose your job because you can't get back to the United States. Maybe you've been granted asylum and you need a petition for your family members who are still in harm's way abroad. Those are all different cases, but the way I work is I need to know those harms and I need to describe them. And, we'll file a federal complaint. Sometimes, we can talk about venue, but if you're filing against the Department of State, normally you're going to be filing in Washington, D.C. If you're filing against USCIS, it's going to be perhaps where the service center is, who's taking or not taking action in your case, or it's going to be where you reside if you're in the United States. Everybody always asks, what are the fees? How do you charge for this? And I try to bill my time at a flat fee so that there's certainty, but I'm always going to base it on my time and the time to litigate. And I'll bill in stages. And so what we want is we're going to have a complaint. That's going to be the first thing we file. That's going to tell the government, you're not taking action on my case. It's been this long, and this is how I'm being harmed. And we're going to serve that on the government via certified mail, and they're going to have 60 days to respond, okay? But that stage is how I'll bill. I'll bill for that stage. If the government settles, meaning you get what you want, whatever action it is, the case goes away. Nobody takes any more money. You get what you want, and the case is voluntarily dismissed. If the government fights in a mandamus, they're usually going to file a motion to dismiss, and that's going to take a second stage and a long time. We're going to bill for that, okay? And then a judge is actually going to decide, am I going to dismiss this case or am I going to let it to go forward because the government is actually delaying cases? Now, I should tell you, almost always when the government fights, they win. Flat out, they win. They know what a delay is versus an unreasonable delay. That being said, about 80% of the time when we file mandamus, they do settle. They take the action. They see the harm. They see the delay. Okay. But let's say you survive a motion to dismiss and the judge says, I'm going to allow the case to go forward. We'll go to a final stage, which is summary judgment. And we'll file motions asking the judge to rule in our favor because the delay has been unreasonable. And in fact, you deserve an order compelling the government to do what it has not done for you. And we'll bill for that stage. And so I'll talk about generally, because they range, the fees range, the cases are always different, immigrant visa case, non-immigrant visa case, how quickly the person may need it done. But generally the fees for an attorney are going to range between $4,500 and maybe $7,500 at that first stage. That's usually where I'm in. I'm in that range. Again, there's how many family members, what's the benefit, how long is this going to take, do you need it, how do you need it? So it's going to be, it's not about, necessarily, oh, you're billing me X for, it's always about time. It's not I'm treating anyone different. It's really, I need to make a forecast about what time I need to spend making sure that you win, because that's really the game. We need to be incentivized so that our interests align, so that if you win, meaning you get what you want, that that I'm working as hard as possible, because in a delay case or mandamus, you've already waited long enough. Okay. And so that's the way it works. And I handle these, it's a large part of my practice. It's what I do. It's really, when you're talking about immigration litigation, there's three categories. There's your delay mandamus, there's your denial outside of removal proceedings, and then there's your removal proceedings. I've been ordered removed. What do I do now stage? Okay. There's a little bit of a niche practice also in detention. I don't usually handle those, but I'll handle the other three. So that's our topic of today. That's on mandamus, and I hope you enjoyed it.
In which situations the government settles or fights back?
The government typically will fight certain types of cases. So in the last year to 2 years, they've fought all delay cases for an EB-5 immigrant visa petition or an I-526. The processing times at USCIS are currently 60 months. And the government has fought against claims that that's an unreasonable delay. Another type of case where they've fought have been U visa, or the victims of crimes who are seeking employment authorization or a bona fide determination, so they can have their case processed, at least at the initial stage. The government has commonly fought those as well. And again, those processing times are also at about 60 months. Other cases where they've been less likely to fight, or, I filed for asylum back in 2019, and I haven't got an interview yet. And I want an interview because I don't have status, and I need status, I just need an interview. So they've been settling those. But by and large, they settle, again, like I said, 80% of the time.
So explain to me again. So normally with cases like EB-5, investors who have at least $500,000, the government says, no, we're not gonna try to make it quicker for you, or
it's not quicker. They don't see that there's a delay. So that they're arguing to a federal court that 60 months is not unreasonable to process an immigrant visa petition for an EB-5 investor. Yeah.
Okay, and then U visas. These are people who are victims of crimes, and they were like collaborating with governments, like officials, like police or whatnot, and still they don't get work permits for how long?
Years. The process is, there's a 10,000 person cap per year on U visas, and so it's created a massive backlog, like decades long backlog. But for people who are just entering and filing for U visas, they have a new process that they created to help speed up the process, and they try to make a bona fide determination. But even those are taking 60 months. And so people have to wait like 5 years before they would have work authorization if they have no other ability to gain work authorization. And the other thing with, I guess I don't know if it's unique, but it's certainly a part of the U visa process, is those people can also be ordered removed or put in removal proceedings if they're here unlawfully.
And you sue the government to make sure that they're, processed quickly and they get work permits quickly, and the government normally wouldn't settle and would proceed to fight you in court?
No, I think, again, with the U visas, it depends on, again, how long and how bad the harm is. There are certain people who literally are not going to make it unless they get work authorization, meaning they're not going to make it financially. They can't stay and wait 5 years without working, or they don't have a family member who can support them. So they don't fight those as, I guess, as much maybe, or as many times as they do in maybe EB-5, the realm. But again, anything I'd say less than 2 years, they're probably going to fight you unless you can show that, you really are harmed, because it's a weighing of the factors. There's really 5 factors that they look at, that courts will look at when they decide these cases. And it's always going to be the 2 that are most important are usually, is the government following some type of like processing rule? And then the other one is going to be, well, what are the harms? What are the harms if the person does not get a benefit? And so in a U visa context, the harms can be fairly significant. So I don't want to say that, it's tough to paint too broad a brush with U visa cases, but commonly those have been defended. Yeah.
So the government does have a heart, but not necessarily. So normally we would expect that people with U visas are they're victims of crimes, okay? So they're already kind of disadvantaged as opposed to investors who have lots of money.
Well, I mean, again, I think that sometimes it's a false trap. I mean, it's just a different visa category. I don't want to say, there are a lot of EB-5 investors that actually use every dime of their savings to invest in a project. I don't want to call them, I mean, I think there's a lot of ways in which EB-5 investors are targeted as being wealthy and actually discriminated against because people think, oh, they can wait, it's fine. And that's not so true, because keep in mind with an EB-5 visa petition, it's just the first step of the process. They still have to go and get a green card if they cannot file in the United States in status, and they have to actually get conditions on that permanent residency removed. And so they have to keep their investment for, decades or if not longer. And, one of the problems with the EB-5 program in and itself is that there are bad actors out there. There are people who are trying to dupe foreign investors into certain projects to take their money. And what's the problem is nobody cares if you lose your money. Meaning nobody in the government. If you lose your money because you've been, victim of fraud, you don't get your green card.
Yeah, unless you can become a U visa, right?
Yeah. Well, yes, yeah. Although the U visa categories, there's specific categories of crime. I'm not so sure fraud would get you a U visa.
Okay, and so can we talk about asylum, please? So I personally know lots of people who are my friends who have filed for asylum in 2016 and still haven't gotten an interview. Yeah. So that's a huge problem for asylum seekers. They're just here and they have built their life here, like have their kids here and so on. So is there a way for them to file a mandamus lawsuit against the government to make the government schedule their interview like in a month or like in a week?
Well, you see, that's the thing. We can't really control when, but the lawsuits that I filed for asylum delays have all got an interview. Yeah, I mean, those are good cases, because what the government did, I think, foolishly, is they went from processing asylum cases first in, first out, meaning if you filed in 2016, you'd be up before someone who filed in 2020. But then they switched it and they started going last in, first out. And so if you filed in 2020, you were in a better position than someone who filed in 2016. And that's crazy to me, because oftentimes, well, not often, all times, asylum is something that could be time sensitive, so that your evidence is and your claims are going to change with the country conditions in your home country often. So by the time you get an interview, if you filed in 2016, your case is probably stale, meaning there's work for you to do, there's going to be work for the government to do. So it's in nobody's best interest. And the other thing is this, you're 7 years, 8 years into it, and you probably have work authorization, but nothing else. And, you're not even a conditional resident. So for those cases, solid claims. I will say though, people who filed affirmative claims for asylum and have not waited, not everybody wants that interview. Maybe they don't think their claim's so weak. Maybe the country conditions have actually improved in their country. And they maybe they hired a notario and they have some really big problems with what they filed, and they need to change it. But I can, if you have a strong case and you just are fed up and you've been waiting 5, 6, 7 years, 4 years, I mean, again, it's not about an abstract time. Yeah, you should file and get your interview. You deserve it.
So from your experience, if an asylum seeker with a strong case starts working with you and you files a mandamus lawsuit, when can they expect that interview to happen?
Yeah, so it depends on the venue, meaning where are you located? And we filed a couple in Los Angeles, and they started to go from scheduling people within 3 months to scheduling kind of 4 to 5 months out right now. It changes, but I can tell you, if they hadn't filed a lawsuit, they're never going to get an interview. So Los Angeles is a very packed asylum office. If you were in Boston and you filed for mandamus, you could get an interview within a month. It's just, It's really because asylum offices are really like region specific. The Hartford office, Boston office, LA office, Seattle office. There's offices across the country. So it really depends on where you are.
And if we're talking about immigration courts and asylum, where there's the defensive process, meaning the person either crossed the U.S.-Mexican border and asked for asylum, or they already had a USCIS interview and then they got denied, and then they have another chance to prove their case in court. So can you help those people who have been waiting for the court for a very long time?
Yeah, so I don't do the removal proceedings until they want to file a petition for review at the Circuit Court of Appeals. But,
can you explain it to me? I didn't understand it.
Yeah. So there's, immigration can really be divided into non-removal or removal. And asylum seekers often will cross both paths, because if you're not granted asylum affirmatively, meaning outside of removal by USCIS, you're going to be put in removal proceedings. They have to do it. They refer you over for removal proceedings. And once you go into removal proceedings, you can renew your case for asylum before an immigration judge. And the immigration judge is going to give you a thumbs up or a thumbs down. And immigration courts are incredibly backlogged. I'm not aware of any successful mandamus opportunity to speed up the process. And so an immigration judge, and in fact, you can't sue it for delays in removal proceedings, because removal proceedings are really tightly controlled, meaning you have to go through the process of removal. And so an immigration judge is going to give you a thumbs up, thumbs down. You can appeal to the Board of Immigration Appeals. And if the board says, no, you must leave, you have one opportunity to go to a Circuit Court of Appeals, First Circuit, Second Circuit, Third Circuit, Fourth Circuit, all the way to the 11th, depending on where you are. And that's your recourse. But delays in removal proceedings, no.
Okay, I understand. So yeah, mandamus is not applicable for those who have to go to the court to fight for their asylum, or only the SCIS process. Okay, so can we also talk about delays for people who have filed for EB1 or EB2, work-related, I would say that. Green. So can you help those people to get their green card sooner?
Yeah, I mean, so we're talking about, if we're talking about EB2, one of the things we have to deal with is the visa bulletin. And do you have a visa that's available? Because if you don't have a visa that's available to you, you really don't have a case to delay, because there's no remedy we can get you. And a lot of times there are incredible backlogs, family-based backlogs and employment-based backlogs, meaning you're cut off from getting a visa. Think of like siblings of a U.S. citizen, you wait decades. So for EB1, EB2, EB3, I've done a lot of work for Indian nationals who were delayed or skipped, meaning they should process them by their priority dates, which are the dates that they maybe had a labor condition application filed for them called an LCA. But if they're current and they have been skipped over, delays are good cases in the EB1, EB2, EB3 context for sure.
People from India, they already have like worse conditions than others, because they have a whole kind of, quota in line, right? For EB2. So they have delays on top of that. So if the delays is kind of on top of that thing, you can help them too, correct?
Yeah, no, I mean, I've done a lot of cases, because in the last 2 years or 3 years, what happened was the dates for Indian nationals advanced so much. So it opened up because there were a lot more employment-based visas available. And the upside was a lot of people got their green cards after waiting decades. The downside was the government didn't follow the order of consideration, and some Indian nationals, for whatever reason, did not get the green cards they deserved. And those with priority dates of 2011, 2012. And there are still people out there, I represent them all the time, who, for whatever reason, have not got their visa yet in their green card. And so if they have the difficulty in this environment right now, as we sit here, is the 2023 available visas are not like we've seen in the last 2 years. There's less of them, and dates are moving back. They're retrogressing again. So, yeah.
Okay, so is the government kind of friendly towards EB1, EB2, EB3 cases, or are they kind of like more rigid about it?
It really depends. It depends on if they've skipped people, and how long the delay is. For EB1, it's usually going to be about a post-interview delay, because they don't really delay those all that much. People can get their EB1s adjudicated. They can actually file for premium processing if it's an EB1A. The difficulty with EB1s is denials more than delay. For EB2, EB3, especially with Indian national backlog, they haven't fought us yet, knock on wood. Haven't fought me, because usually my clients have been skipped. So there's not only delay, they've skipped them. They've not adjudicating them in order, which they should.
So normally, they're likely, if an immigrant like waiting for the EB1, EB2, or EB3 green card is going to sue the government using this Mandamus lawsuit, then they're kind of likely to settle even before court, because the government will be like, oh yeah, I think we made a mistake here. So here's
It's not before court. It's that magic time where you filed your complaint and served the government, which starts a 60-day clock. So between the starting of the clock when you serve the government with your complaint and their answer date, which is 60 days or 2 months, in that time, what I do is I can talk to the government. I have a direct line and say, hey, what's going on in this case? Why is this person being, how do we work this out? How can we fix this? It works. Again, I think you also want to know your clients. I mean, I do want to, kind of tell the audience, I guess, is, don't go hire someone to do a mandamus. Make sure they are responsive to you and they know why you're going to do it. And what I mean by that is, how is this impacting your life? You need to be different than everybody else. Okay. And I try to make sure that my clients are like, what is the one thing that's different about you? Maybe you haven't been able to visit your mother in India because you have H-1B. And if you travel abroad, the processing times, you're never going to get back. Or maybe, if you have a family separation case, you filed for an immigrant visa petition for your child, and he's in overseas and you're in the United States. And, obviously the harm is obvious, but it's very specific to you because it's your child. So you just want to make every case unique.
Can you give other reasons why you kind of deserve a mandamus in the eyes of the government?
Oftentimes it's where you're really just, it can be, there's no reason to explain the delay. They may have lost your case. You're about to lose your benefit, meaning if you don't get a decision, you're either going to lose your job, you're going to lose status, or you're going to trigger a 3-year bar or 10-year bar from being admitted back in the United States. So sometimes people have no choice, because if they don't get the benefit or action on a specific date, it's over for them. Meaning their job, their visa, whatever it is they're seeking. Can
a child who is about to turn 21 be a reason as well?
Oh, 100. I mean, those cases are the best. I mean, and honestly, the government does a fairly good job of taking those cases without having to be sued. So those cases, those age outs are for sure. If you have a child who is about to turn 21 and you're not getting a response from either a consulate or embassy or USCIS, 100%, you have to, because you can't go back later and claw back. For sure. Yeah, I've done that. I actually had a great case of an adopted child who needed to get her immigrant visa before she turned 18 to be for her to be able to get a citizenship, not even a green card, citizenship. And we were able to file a mandamus and get her the visa, and just a great case. I mean, the adoption cases, the child cases that I work on are my favorites. I mean, if I have favorites, I just love working with the kids. So
can you also give another example of an adoption case where you made the government make a decision on either green card, a visa, or the citizenship?
I mean, I can give you kind of an example that it's not a great story. It's not a good story, but right now I have a case for a family who cannot get a decision from because the State Department will not process any adoption cases from Nepal, and we're fighting on that, and it's still open. So, I mean, I don't want to sit here and say we always win. I mean, sometimes you have to really, when you litigate cases, it's you really have two opposing sides, and so it's not just like, hey, we're on the same side. No. You have two different sides. I mean, that's the whole nature of litigation. So right now we're still trying to get through that and trying to work through what we can do for this child. But we may have to.
Is this child in Nepal? Is this child in America?
Yeah.
Can you tell the story a bit?
I mean, I don't want to talk too much about my client's case, but yeah, the child's in Nepal. She's adopted by United States citizens, and nobody questions the adoption, but it's not. You don't need. That's not the only requirement to get an immigrant visa for an adopted child. You have to do more than just adopt them to get an immigrant visa. And right now, there's a specific policy at the State Department and USCIS where they're not processing any visa petitions for adopted children. So
from any countries?
No, from Nepal.
Oh, from Nepal. Okay. Can we talk about other family reunification cases where you do file mandamus? So give some examples, like how is it different from like work-related or investment-related cases?
Yeah. Well, sometimes a family separation can be a work-related issue. You know, when you have maybe an H-1B spouse who's in the United States and their H-4 spouse is overseas and cannot get their interview, or their visa, family separation. So family separation is not about just having a family-based immigration case. Family separation can transcend any immigration category. So I do a lot of those cases, actually. You know, sometimes you'll have a student on an F1 and their F2 spouse, derivative spouse, cannot get their visa. And it's heartbreaking. And so cases like that, a lot of family separation, but it really, again, it's not about the visa category. It's about the harm. Like what is happening with your case? So in non-immigrant categories, you know, those family separation cases are always good. A lot of times people will get a job offer though, turning to just strictly employment. They'll get a job offer, but if they don't come in and start working, it goes away. And so the whole basis for getting a non-immigrant visa will be, you know, useless. It won't work. Sometimes people will have an E2 investor. You know, they're from a treaty country and they've started a business or they're starting a business and they can't get an interview appointment. And if they don't get an interview appointment, like the business isn't going to, you know, survive. And so you have these delays that put an enormous amount of pressure and it's so time sensitive. And so if you don't actually do the job, meaning process the visa, it's over. You know, sometimes when you file in the United States, a family-based case, and you can get interim benefits like work authorization and travel authorization. Sometimes USCIS doesn't do a great job of actually producing those documents. And so I'm a US citizen, I'm sponsoring my spouse for a green card, and my spouse is here in the United States and we're waiting and we know we're going to wait for our interview, but she or he can't work. And it's been 9 months, 10 months. That's too long. So again, it's usually, if you're going to break down the types of harms that I look for, it's going to be like family separation, economic harm, severe economic harm, status expirations or unlawful presence triggers, things of that nature. You know, so financial, family, sometimes it's humanitarian. Like I'm in, Ukraine and went back before the embassy closed, or I'm, you know, maybe I'm a Russian national, or, you know, maybe I'm in, you know, anywhere in the world where there's civil strife. And if I don't get a visa now and get out, I'm in trouble. So things like that.
Interesting. Can I also ask about diversity visas? So people who won green card lottery and they haven't been called for the interview. Yeah. Can they actually sue the government to be called for the interview or no?
I don't think they can this year. You know, I've done a lot of diversity visa litigation since 2020. We're still, you know, have a class representative of a class of 2020 visa applicants, diversity visa applicants, and we have our case on appeal. The last year I filed on behalf of some diversity visa winners, like about 150 of them in two cases where at the beginning of fiscal year 2022, they weren't doing enough. They were never going to reach. And then they got sued and they actually exceeded the cap. The cap is around 54,500 visas that they had available, but they actually surpassed that last year, which is unlawful, but they did it. So I think a lot of times people will have used lawsuits in the past to get a diversity visa interview. I don't think it's a successful strategy in fiscal year 2023 because they're processing them. They're not doing it in constant. But what they're doing is specific consulates or embassies are not doing it. Because, you know, when you win a diversity visa, you have 6 regions: Europe, Africa, Oceania. They have some North America. They have Asia. I think I missed one, but
North America.
yeah. So but the African region, I don't know if it's intentional or not, but their embassies there, they're not producing or processing the visas at a sufficient rate. And so, like, if you look at like Addis or Accra or Nairobi, they are just not producing enough. They're never going to get through their backlog of allotted lottery winners. And it's unfortunate, but I don't think a lawsuit, at least it hasn't been in the recent past, successful in that type of case. What you could potentially sue on is, I got an interview, and they put me in administrative processing, meaning they haven't said yes, they haven't said no, they've said nothing. I've given them what they asked for, and I'm stuck. And I know that if I don't get my visa, or I should know, if I don't get my visa by September 30th of 2023, I'm out. I can't get it later. So in that situation, lawsuits could be successful to trigger a decision post-interview.
Okay, I understand. So let's talk about tourist visas. Can you actually see? Well, it's heartbreaking. Lots of people cannot get tourist visas. Lots of my friends, my employees, they cannot get their parents to see their grandchildren because they were denied tourist visas in the U.S. embassies abroad. So is there a way to sue the government to make them issue a tourist visa?
No, I mean, not on a denial. If it's a denial, there's no way, because you have consular non-reviewability, meaning, you cannot challenge almost in every case a decision to deny a visa from an embassy or consulate. You cannot do it. And a B1, for sure, you cannot do it. I've had success challenging B1, B2s that are held up in, like I said, administrative processing, where they're waiting 1 to 2 years, 3 years, 4 years. I've had one 6, and they haven't received a decision. So in those cases, you can sue for delay, but you cannot sue because they denied your non-immigrant visa for whatever reason, quite honestly.
So, okay, I understand. So if you apply for a tourist visa and you're in the ministerial processing, then you can sue the government and make them issue a decision, which not still would be positive. They may still deny you, right?
Right. Yeah. A lot of times people will come to me and they get so fed up because they just want a decision. They don't care what it is anymore. They just want to know. But most times, I'd say over 90% of the time I have it, it's a yes, because I want to make sure I do my homework. I mean, if someone comes to me and says, hey, I want my B1, B2, I just have this little murder conviction back in the day, I'm going to tell them, I can't take your case. I mean, that's a denial. I mean, I don't know why they haven't denied you yet. But no, I mean, if I do my job, I mean, I want to make sure you're eligible. I'll put that in the complaint. My client's eligible. There's no criminal history. He doesn't understand, or she doesn't understand why the visa is being held up.
So can you explain again that the government, it's not personal to the government? So lots of people ask you, hey, are they gonna retaliate back? Is they gonna do revenge thing on us? Can you just talk about this and explain?
Yeah, every client has that, and it's a common concern, and it's one that's, from a human perspective, rational. Like, oh, if I do this, aren't they going to just deny or fight me? Again, I mean, I worked for the government for 15 years and I never took it personal or retaliated against someone. In this country, it's more about an exercise of your rights, and you're not getting a response from the agency. So this is just the next step. It's not, no one's angry at someone. I mean, you're paying for it, right? You're saying, hey, you skipped me, or hey, I need a decision, or because, I'm running out of time here. I've never once seen a case of retaliation against one of my clients, and I've never done it to anyone. So I understand the concern, and I understand from a human, kind of perspective, like, oh, if I do this, they're gonna get mad at me. But it's not like that. It doesn't work that way. Oftentimes, I remember, in my experience in the government, when I got a case, I always said, my thing is, oh man, what did we do wrong here? And you have to take it from that approach, because sometimes there's a good case for delay. And like I said before, most of my cases, more than most, like a high percentage of my cases often do settle.
So how many cases have you kind of received Mandamus cases when you worked for the government, and how many have you done as a
Oh,
immigration litigator since you started helping immigrants, starting playing for the other team?
Since I left the government,
Yeah.
I don't even know. I don't
Like,
know. Because I've done some class actions. I mean, I've done some giant cases where we've represented 23,000 people, or maybe even higher than that. When we're suing for the healthcare insurance proclamation or diversity visa ban, or but I don't know, maybe 400 or 500.
So you represented. Will it be correct to say that you represented tens of thousands of immigrants in Mandamus cases?
I don't know. I mean, I don't know about that. I mean, I've represented probably on a class basis, definitely,
Okay.
because we've represented classes of diversity visa applicants and those that were going to be subject to the healthcare insurance proclamation. But yeah.
So it's fair to say that when you worked for the government, you kind of received hundreds of Mandamus cases?
Oh, when I was at the government, yeah, we did them all. I mean, I never wanted to litigate any of them because I was doing other things, but I had to monitor a ton of them. Yeah, for sure. A lot of cases. When I worked at the government, we would get, I mean, because there were, backlogs have kind of ebbed and flowed, but back in 2006, when I joined the government, yeah, I mean, I think every attorney had over 200 Mandamus cases that they were assigned to. So Mandamus was something that we were responsible for, but we didn't necessarily litigate them all. Like I said, we settled them. We would try to get them done, meaning administratively, like call up USCIS, hey, take the action. Call up Department of State, hey, make a decision. So yeah, I mean, inside and outside the government, it's the same game, right? It's a lot easier to just get the action taken care of than it is to fight in court. You're expending a lot of resources and energy if you're going to fight Mandamus. It's a lot easier to take action on a case that's already pending and been pending a long time.
You mentioned that sometimes you can just talk to the other side. Can you just elaborate on that a bit? So if you have a client and you file a lawsuit against the government, the Mandamus lawsuit, so do you call somebody in the Department of Justice and say, hey, let's settle it? Or how does it work?
Well, I represent a client, and the agency is going to have a attorney that represents them from the Department of Justice. And yeah, I mean, you send an email, have a conversation, get on the phone for sure. Yeah, and we want to talk about it. And sometimes if it's a really egregious situation, I will do that. I may do it anyway, or they'll call me and say, hey, can you agree to a little bit more further time for us to reply? I mean, it looks like something's happening here, but that's one of the extreme benefits of the Mandamus, because a lot of times my clients will say, I don't know what's going on. I've called the congressman, I've called the senator, I've sent emails, and I know nothing. And there's no doubt that I could figure out what's going on. And that's usually one of the best, quick things that you can take care of initially. It's like you can actually understand a lot more about what is happening in the specific case once you file a complaint.